So hello, good afternoon, welcome. Hopefully you can see our slides on the screen, and if you want to, me as well. I'm Michael Redston. I'm an associate solicitor at Aaron and Partners in the employment law team. And today, HR Lunch Club is on key policy updates, the things you need to make now, but actually I've gone a little bit wider than that. In preparing for this, in the last week, you'll probably be aware that all our major political parties have updated or provided their manifestos, and some of which pronounce on what employment law changes they might make in the future. And there are already some slated legislation changes over the next 12 months, which may or may not happen, I suppose, which I'll sort of cover off a little bit as well, just to give a bit more of an overall view of what what paperwork you might need to change in terms of contracts and handbooks and policies. So again, the beginning stop now, so I think we can crack on safely. Actually, so here's our agenda. I was going to cover what policies employers are legally required to have, the recommended policies, the things that typically companies will have. It may depend on size, of course. Other suggested policies, which sort of covers hot topics as well, how you might want to deal with those. And then new policies to keep up with changes to employment law. And as I said, there's a bit of an election special that I've added on at last minute, if I will. And then just a note on ensuring your policies are rolled out and implemented. As we go, if anyone has any questions, if you want to drop them in the chat, I will try and keep an eye on it. It's sort of in a screen over away from me, but at the worst, I can pick things up at the end. And if I suppose if anyone's having any trouble with audio, then put it in the chat, and hopefully our team will be able to help you. But I trust everyone can hear me safely now. In fact, I'll just get the chat box up so I can just see if anyone's there. We go, that's better. Right. So legal requirements. I would imagine a lot of you are already pretty well aware. There are very few legally required policies that a company needs to have. And a lot of it depends on things like your size and whether something needs to be in a policy or perhaps in the contract. So disciplinary procedures and rules and grievance procedure and information about pensions all need to be written. They may be in your contract of employment, or they may be in their own standalone policy. I think most companies obviously have some information about disciplinary and grievance in their contract, certainly about pensions, even if it's just to say you'll be auto-enrolled in whichever scheme. But otherwise, you might have a full-on policy that details in much greater detail how you deal with disciplinaries and grievances, for example. Health and safety is a legal requirement for companies that have 5 or more employees. And I think there's pretty strong reasons for including one, even if you had fewer than 5 or more, to be honest, although that may depend on the circumstances. Whistleblowing is also one that sorry, we've still got quite a few people just coming in, so I'll just give it a second. But whistleblowing is also one that there isn't actually a requirement in UK law to have a whistleblowing procedure in place, except in certain circumstances. I would say it's strongly required, even if you're not within any of those circumstances. But for example, listed companies are required to have written whistleblowing arrangements or to explain why they don't. Interestingly, large banks, building societies, other organizations that are financial bodies and public bodies are all required to have whistleblowing policies. Now, the ones that I've included on the right-hand side here, the strong reasons for including, are ones where, even where it's not required by law, it's going to help protect the company. It's going to ensure best practice. So bribery, anti-facilitation of tax evasion in some circumstances will obviously, show that the company is complying with its duty to ensure that there is no corruption within the organization and so on. Equal opportunities, obviously is something that will help in dealing with any allegations about discrimination and those kinds of matters. Data protection, obviously you need to ensure that you're complying with data protection regulations anyway, but by having a policy, it helps everyone understand what their duties are in relation to data protection and retention and so on. And as I've said with whistleblowing, even where it's not a legal requirement, clearly it's a protection which is envisaged within our legislation to protect employees, and therefore in order to mitigate against the risks of whistleblowing detrimental dismissal claims, it certainly helps to have a properly implemented policy, and it helps to ensure an open and transparent business. I'll just I haven't put it in here, but just note about anti-slavery and policies. Businesses with a turnover of more than £36 million and public bodies with a budget of 36 million or more would need to publish an annual modern slavery statement. So anti-slavery, modern slavery policies obviously are usually included within that, and it makes sense to have that in those much larger businesses. So those are the ones that you need to have, or you really should have. And then there's a lot of other ones which you might consider. And I don't think this is even all of them that I could think of, but I put the bulk of them down. These are the things that I would suggest you may want, but obviously it entirely depends on the organization. It may depend on your size. Smaller companies typically want fewer policies, and there is a risk to having too much it written down in a way that it prevents a certain level of flexibility and change. So it does depend on the size of the organization, the way it's structured, and so on. But you may want to have office rules or responsibilities or any duties that are owed, or kind of requirements in a particular profession, for example, dress code, attendance, timekeeping, all these things to make sure that things are run smoothly and that employees know what they need to do. If they've got an appointment or so on. Holidays, which are just I'll touch on in due course as well, although I've just realized I think I've left it off the slide itself. But holidays and how they're dealt with, obviously you would have possibly an more full annual leave policy anyway, but you might also have time off in lieu. Do you give time off in lieu? Expenses, how those are dealt with, smoking, no smoking in most cases, accidents, internet and email, telephones, those kinds of things. I'll mention social media as well, but that's something I've put on one of the later slides as something that I think is still somewhat of a hot topic as to how you deal with people's use of social media outside of the workplace. So that's kind of the day-to-day, what I suppose I'd categorize as the day-to-day working arrangements type of policies or procedures or notes. And then you've got the company policies. So sickness, absence, meetings, capability, procedure, equal opportunities, anti-harassment and bullying. So again, I've mentioned already strong reasons to have those kinds of policies in there. It's important that your managers understand how to manage sickness, absence. It's important that the employees know how it will be managed and what the procedure is for calling in when they're sick. And the same for performance in terms of performance capability as opposed to sickness capability. Equal opportunities, anti-harassment and bullying. Obviously, these are all designed to make a safer, happier workplace environment, but they will also help to mitigate and defend against the risks of claims relating to those kinds of issues. Equal pay. Obviously, most organizations are required to put an equal pay statement out annually now as well. And I'll get to some changes that might be in the offing about that if I have time. Dignity at work, I suppose, links with equal opportunities, anti-harassment. And then you've got also the family, all the various types of family leave and rights for, in relation to family and parenting and adoption. And most of you will probably already have these, I'm sure. But the law does develop quite quickly, I think, in terms of these. Shared parental leave is not that old, really. Time off for dependents, compassionate leave, but you've also, as I'll touch on later, we've got some new ones like care leave and neonatal care. So, oh, sorry. Yeah, so it's worth just considering, I think, what do you what is going to be useful to you? What do you need? What do you want? And obviously we can help you. It's the kind of thing that having that kind of discussion with a company, with the HR or the owner of a business is always an interesting conversation to have as to what they actually need. And I'd prefer, when I work with a company, I prefer to have that conversation rather than just send you a template and work out what's actually going to be useful to you. There's no point giving you 50 policies if actually it's not going to suit your organization and you're smaller maybe and you only want the key ones. So those kinds of conversations are worth considering, and it's worth, when you review your policies or your handbook or what you have on the intranet, hopefully you do that annually at least, you consider what new ones you might want to add, where you need to update them, where they don't fit anymore, and also you may consider whether you need them at all. So there are things like redundancy, which I would recommend, but isn't necessary. And I think certainly for larger organizations is something that's used more commonly. Retirement, again, and career breaks are things that, again, that it really depends on the kind of company you're in. So moving on then from recommended to hot topics, or things you may want to add. And I've put a few down here. I'm sure you'll think of more. There are certainly some that suddenly become something that has a kind of groundswell underneath it, and an awareness amongst employers and employees that it's an issue that is being addressed today. Stress at work, or stress generally, is something that I think, thankfully is something more and more that is being dealt with better, and with a kind of with robust policies. You can understand, and your managers can understand, how best to manage employees who are suffering with stress, which, but it may be, rather than having a standalone policy for it, you may want to fold that into your sickness absence policy, for example. With menopause, of course, it is actually very much I think a hot topic at the moment. It is something which a lot of organizations are coming to us and asking for a menopause policy, or for advice on issues around menopause. And it will help if there's something in writing, and it doesn't need to, again, it doesn't need to be a standalone policy. I was talking to a colleague earlier, it may make more sense to fold it into any kind of general well-being approach that you have, any well-being policy, but to enable staff to have a better understanding of the issues that arise for women suffering menopause. Someone did mention the male menopause, which I think I understand is called the andropause, as well. I suppose that may be an issue. I have to admit, it's something I need to educate myself on too. But it will help people to know how to best support someone who is experiencing menopausal and premenopausal symptoms, and to ensure as well then that employee feels supported, and you are then reducing risks of claims and so on. And I think generally awareness of issues like that, especially something which has symptoms which might affect how people behave, it certainly helps helps people to understand how they should behave around someone who's going through those symptoms, and how they might support that person, rather than, unfortunately, you'll see the odd ill-advised comment in the name of banter, which, people who are going through illnesses, whether that's menopause or anything else, or things like maternity, even coming back off maternity, people make comments that are ill-advised, because they don't really have an understanding of what that person's going through, and that person may have quite thin skin at that time, and may be feeling not at their best. Gender identity policy, again, it's really a question of your organization and how you approach those kinds of matters. I think it's one of those policies that can really help people to understand the company's stance on on people assigning identifying their own their gender and how they could be treated and supported. You know, and obviously some places will have gender neutral toilets and so on, and how those should be dealt with. If that is a direction that the company is going, then it's very helpful to have a policy in place to support that. I mentioned social media already. Clearly, it's really just a way of ensuring that employees understand that even when they're on social media that's unconnected with work, it may become connected with work, and you know that their behavior on social media, even outside of, you know, in their personal life, can be reflective of their job and their employer, and can affect your reputation. Generative AI is an interesting one that I think is really going to need to be grappled with by employers going forwards and companies, and you know, a policy is a really good way to do it. Will you allow the use of AI, Chat GPT, or any other generative AI within the workplace? Is it something? It might be something you typically already use quite frequently to create your work. But even if that's the case, you know, there are a lot of things that need to be considered, not least making sure that employees know that they can't just generate something with AI and then publish it without checking it, because we've all seen things that are created that are not well proofread or well checked, and don't always reflect what you want it to say. So and we've done a session on generative AI quite a while back now, so maybe that's something to revisit again. I know that there are some changes in the international or the European definition, at least, of AI and how they're going to treat it in law. So it may be something to revisit in one of our future updates. So then we've got some new additions that hopefully everyone has already been aware of and has already approached and changed their policies accordingly. Flexible working rights have changed, as I'm sure you're all aware. It's now a day one right. An employee can make 2 requests a year. The company's deadline to respond is 2 months instead of 3 now. And employees, when they make the request, they don't have to explain the impact on the business anymore, which used to be a requirement. But employers do have to explain. If they're going to refuse it, you have to explain and you have to consult. So that needs to be in your policy. Most companies now, I think, have a flexible working policy, so that needs to be updated if it hasn't been already, to reflect the true position. Carers leave came in with the Carers Leave Act 2023. That's 1 week of unpaid leave per year. This is one where, and I've said it all before, actually, you don't have to have a policy for all of these things, but it is one to consider or to add in, and certainly it should be referred to with new Section 1 statements or contracts of employment as a statutory entitlement to leave. It's unpaid leave, so you don't need to pay unless you want to. Obviously, company pay is possible, but you know, you don't necessarily need a policy, but at the very least, it needs to be referred to within a Section 1 statement so that employees are aware of their rights. Then there's paternity leave changes. So that can now be taken, instead of just in either 1 week or 2 weeks in a block, you can now take them in separate weeks, and they can take it any time within the first year of birth. And instead of and now they can give they only have to give 28, that should say days, actually, sorry, I think that's 28 days notice for each week of leave. So that should be 28 days notice for each week of leave. I'll edit that before slides go out, if they go out. That used to be 15 weeks notice, now it's 28 days. Maternity and adoption. So obviously paternity leave, again, almost all companies will have a paternity leave policy or something in writing about paternity leave rights. So that needs to be updated. Maternity and adoption, again, you will have maternity and adoption policies. Whether you put this in is a real question mark, though. Increased redundancy protection, as you're probably aware now, the protected period has been extended out essentially 18 months from the date of birth. So you know, there isn't a require to put that in a policy, but you know, you may wish to, if it's something that you already have in your policy about redundancy protection, or if you have a redundancy policy that refers to it, then clearly you're going to need to look at whether that policy is now correct. just to highlight what the protected period is. What has come up in terms of maternity, which I think a lot of people perhaps haven't put in their policies yet, is the right to continue to have maternity or maternity pay or full maternity rights, essentially, in the case of a stillbirth or a neonatal loss. So that's something to consider if it's not already in your policies. And obviously, if you want us to look at it and have a check whether it meets that information, then it's worth being aware. But essentially, if a mother or a parent loses a child very early on, or during the birth, then they have the full right to maternity leave. I'll just go back before I go into future ones, because as I mentioned, I think what I've missed off here is holiday, annual leave. So obviously there's been, as you know, there've been lots of changes. The main changes really relate only to irregular hours and part-year workers, which we've covered off in several other sessions. So I won't go into loads of detail, but again, it may be something that you need to address in your policy in terms of their entitlement to pay, to their entitlement to accrue holiday, how they will accrue it, how it will be paid, as you can now obviously have rolled up pay potentially for those kinds of workers. So there are a few things coming in the future. So next month, for those in the retail or more like the entertainment industry, staff there's new rules about tips. Staff essentially the rule is that staff have to receive all their tips. It's unlawful to hold back service charges from staff, and they have to be, where the employer takes the tips, they have to distribute in a fair and transparent manner. And the legislation specifically requires that there is a written policy on this. So this is one where, if you're in that sector, if your staff are paid tips, or you take tips for employees, then or workers, then you do need to make sure that you have this as a written policy. The fire and rehire code that we're promised in summer 2024, I wouldn't anticipate that this needs a policy as such, but I thought I'd throw it in. Just obviously in terms of things that are coming up that we're expecting. I suppose, again, it might very well depend on who wins the next general election. But the government have consulted on fire and rehire, and they're intending to produce a code. And as you'll see, other potential governments, like the Labour Party, for example, would make more wide-ranging changes, shall we say. The Worker Protection Act 2023, I have to admit, I haven't put the date in when it comes into force. I'll have to check that, but essentially it will instill a duty to take reasonable steps to prevent sexual harassment of employees. As you might be aware, that originally was also going to include protection for third parties of harassment, all kinds of harassment, not just sexual harassment, but that was taken out during the bill process. So it now is just duties to take reasonable steps to prevent sexual harassment, which, obviously to a certain extent you had that duty anyway. It's going to be more about being able to prove that you've taken observable steps to prevent sexual harassment. So you may want a policy in there, or certainly you might want anti-harassment and bullying policy if you don't already have one. In April next year, the Neonatal Care Act will come into force, and that will give employees 12 weeks leave and pay when a baby requires neonatal care. So I won't go into the details of that. It's still a way off, but it's just something to bear in mind, because again, you may want to add that to a handbook, or certainly put it into Section 1 requirements when that time comes. So as I said, I'm really hoping you can all read this, because I tried to summarize as much as I could, but as you can see, Labour's gone into 2 columns. I just thought this is new information. It's sort of relevant, or it may become relevant, obviously, regardless of your political affiliation or your beliefs. Clearly, the the polls at the moment are showing Labour are likely to walk it, frankly. And so it's sort of interesting to compare what the different approaches are, and then how that might affect how you might have to change your contracts in the future or your handbooks and policies. So the Conservative Party, actually, their manifesto doesn't really deal much with any changes. It's more about saying how well they've done in the first place over the last 12 years. And but so really all they're doing is repeating things that they've already said they're going to do. So they talked about overhauling the fit note system, and seemingly making it harder, but taking it away from GPs to issue them, but allowing other healthcare professionals to do it. But from the sounds of it, making it harder to obtain a fit note for employees. The implementation of the minimum service level agreements, that's regarding industrial action and strike, which they've already put in, but I think they're just continuing it and implementing it further. They are talking about cutting employees' national insurance to 6% from 2027, so that would be a while away still, and abolishing national insurance for self-employed. So not a lot in the Conservative manifesto as far as employment changes go. But we've got Labour, which is very different, of course. And you'll see I've put abolishment of strikes Minimum Service Levels Act next to the Conservatives' implementation of it. So that clearly, if that happens, if Labour get in, they're promising to remove it completely. Okay, I've got a few questions, but I think I'll tackle those just at the end now, because I've gone past what they addressed. So sorry for missing those, but I'll get to them in a minute. Banning exploitative 0 hours contracts. They say now the emphasis seems to be on exploitative. So they're not saying that no 0 hours contracts. How they would possibly put that into legislation and enforce it, I'm not really sure. How they would define an exploitative contract may well be, I think they'd need to go much more granular on that to explain it. Day one rights, unfair dismissal claims, sick pay and parental leave. Unfair dismissal claims is obviously the big one, and it goes with a bit further down, ET time limits up to 6 months. So they're going to move it, talking about changing ET time limits from 3 months to 6 months. Not necessarily a bearing on policies, which I suppose is what we're talking about today, but it's obviously going to change the game a little bit in terms of employee claims. They're talking about ending fire and rehire, as opposed to the Conservatives, who are obviously talking about how they would approach it, and giving this code. They're talking at Labour, talking about a single enforcement body for workers' rights, consulting on an eventual move towards a single status of worker, which probably in most cases would be preferred, although I think it depends on the industry you work in, the sector you work in. They're talking about a right for a contract that reflects the hours worked. That's for flexible, for varied hours workers. Ethnicity and disability pay gap reporting. I mentioned pay gap reporting earlier, so that's where that came in. In collective redundancies, it would be instead of 20 or more of people being at risk of redundancy at one establishment that triggers the collective consultation obligation, it would be across the whole company. They're talking about a right to switch off, but I don't know much more than that at this point. And then with minimum wage, I think they're just talking about consulting. I know they're increasing it by 20% for people on 0 hours contract at the times of normal demand, it says, to compensate them for the uncertainty of fluctuating hours. I'm not quite sure how that would be really implemented, because I think it would be too difficult to see what is a time of normal demand compared to one that's not. There are plenty of trade union friendly policies, which I won't go into particularly. So most of these, there is a menopause action plan for larger employers that would be required. So you'd have to have an action plan. So that kind of goes hand in hand with what I was saying about menopause being a hot topic and being something you might want to establish a policy for. So most of those, whilst it's useful to know, I mean, they don't necessarily mean that they're going to be changes to policies, but certainly changes to certain approaches and things that you need to put in your Section 1 statement, for example, your contract of employment, the sick pay, the parental leave. Those things will need to be updated to say that it's a day one right. And potentially, obviously, there are plenty of other changes and refinements that may come up within that. The Lib Dems, have a slightly different approach, but wait till we get to reform. They are talking about, and instead of what Labour are talking about with a single status of worker, they are talking about a new dependent contractor employment status, which is in between employment and self-employment with entitlements to basic rights, which to me sounds very much like a worker status. So I'm not quite sure what the difference is really. Obviously, you'll appreciate, manifestos don't go into that much detail on these things. They are talking about changing the burden of proof in employment tribunals so that the employer has to disprove employment status. SSP would be a day one right, and they would remove the lower earnings limit. So there would be better rights for employees for sick pay. They're talking about oh no, sorry, the minimum wage one. I've crossed across from Labour to Lib Dem. Sorry, I mentioned that already. 20% for people on 0 hours contracts, which I'm not quite sure how they define that. Listed companies with more than 250 employees would get the right to request shares. Again, it's only a right to request. I think more relevant to our topic today, parental leave and pay would become a day one right, and they're talking about doubling statutory maternity pay and statutory parental pay. And they're also talking about a kind of use it or lose it month for fathers and partners, paid at 90% of salary. So it's slightly different from paternity pay at the moment. But if you don't use it, obviously it seems like I suppose it's to encourage fathers to take that time off. 90% of salaries, not enough of a cut that you would want to lose out on a month off, essentially, or not month off, but a month with your newborn. They're talking about disability adjustment passports. They're talking about disability adjustment passports, which would give a bit more support for. Oh, sorry,
I can't make it quiet. So I want to make it quiet and I can't.
Sorry, I've just got someone in my ear. Yeah, disability adjustment passport. So where you've agreed adjustments with an employee, reasonable adjustments, then there's sort of certain they're proposing certain rules about noting it down and how it would be dealt with. Yeah. So and that would also help with access to work support and making sure that equipment stays with the person if they change jobs, which I think would probably be quite helpful for employees. Now they are talking about some new protected characteristics as well. Whether this would then mean that you would want to update, anti-harassment and bullying policies or any other new policies. They're talking about caring and care experience protected characteristics. So I think specifically for carers. I'll very quickly go over reform. In my view, it sort of doesn't really say anything at all. It's kind of nonsense. They're talking about abolishing IR35 rules to support sole traders. They say they are going to scrap thousands of laws that hold back British business and damage productivity, including employment laws that make it riskier to hire people. Spot the deliberate mistake in the next one. Replace the Equalities Act 2010 and scrap EU regulations. So it's sort of, I suppose it's what you might expect, but without any detail. So probably not of much interest to you. So final slide, just a very quick comment on implementation of policies. I've talked all about updating and putting in new policies or changing your policies, bringing, if you're new company, starting a handbook or policy suite. But you've got to make sure that they actually read them. They're actually aware of those new policies. There's no point saying we did everything we reasonably could to prevent discrimination if what you did was have a policy that sits on an intranet and no one knows about it, or sits in an office somewhere printed off. So you have to make sure they're aware of those new policies and read them. So you give them memos to explain why the policy is important. Get them to sign it off to confirm they've read and understood it as well. That sort of puts the onus on them to have read it properly. Or at least, if they sign it without really thinking, at least you can say, well, they signed off saying they understood this policy. Checklists on the intranet, so that people can see what they should be reading. And, you may, depending on your systems, you may have things that prompt them, or you may have training videos, or even better, training in person. Obviously, that's something we can provide as well. If you need an external provider, we can come in and do that and go over why policies are important. I think it helps when employees understand why why the policies are there, why are they important, why should they be read and refreshed, and why should you read them, check them every now and then and not just ignore them, because they do tell you how to do things. They do tell you how to fit in with the company ethos and various other things. So I'll say thank you, but I do have a few questions, so I will just let me just move it over here so that I'm not, there we go. Looking a little bit more towards the camera. Right, flexible working request. New starters here have to attend 2 weeks training induction, Monday to Friday. That first question, Ifan, I think, should we have a chat about it offline? Because it's quite a specific question. I think new starters have to attend. Yeah, I would think that that's acceptable. What I'd say about that, though, is it is a day one right now to make a flexible working request. Again, though, the right is to make the request and to have it considered reasonably. It is not automatically for an employer to comply with a request and agree it straight away. So you can refuse requests. Sorry, just to explain for those who can't see it, the question was, requests to refuse flexible working during a 2-week induction at the beginning of employment. So yeah, if you want to talk about that further offline, we can definitely do that. But essentially, yes, I think you've got to have them in for induction, and it's not going to work. You've got a specific set way of doing it. You might be that you've got trainers only at certain times. Then it would be reasonable to refuse a request for flexible working within that 2-week period, but then you might want to consider it after that. And obviously, that might depend again on whether a Labour government comes in or a Lib Dem government, and whether they have thoughts on how flexible working should be dealt with going forward. Right, interesting. So a similar sort of question: if someone asks for flexible working during the interview process, can it be refused at this point, or does it still need to be considered, similar to the day one right? Well, they are not an employee at that point. You can certainly consider it. I mean, I suppose the concern is you need to be careful. I think if you refuse a job application because someone had said right off the bat that they needed flexible working, then you need to consider why and understand why they might be asking for flexible working. They may have childcare arrangements. They may have a disability, which may mean that they potentially have protected characteristics that they're asking for those adjustments for that reason. Disability, particularly, obviously, where you've got a duty to consider reasonable adjustments, you may want to, consider even at the recruitment stage, but technically it's not, they can't make a formal request. I mean, that would be an informal request, so it wouldn't be the one that the legislation covers, but a formal request from day one, I suppose, to a certain extent, if they've given you the heads up when they're interviewing for the job, at least you know what their expectation might be when you're considering them, and then when they start. Can I give an example of reasonable steps to prevent sexual harassment? So actually, yes, this is kind of the policy, having a robust policy, having training. It's not, you can't specifically kind of have someone walking around the office or the shop floor or wherever you are, watching out and spying. I mean, you may have CCTV in certain appropriate places, but it is as much about, as often is the case with defending these kinds of claims, it's about showing that you have educated your workforce about these issues and trained them, implemented policies, had tool time chats if you're on a site somewhere, those kinds of things to enable employees to understand what is the appropriate behavior in the workplace or anywhere when you're talking about sexual harassment, of course. So that it's those kinds of things. And so, if you want, I don't know who's asked that question, but if you want any more specific advice on that, then give me a call. We can talk about it and work out what it is you might need. Okay, and yeah, I've had a comment about my comment on reform. What I'd say about reform, all I'm saying is in terms of reading the policy itself, I'm not commenting on their politics, but in terms of reading their manifesto, it doesn't give any detail on what they intend to actually do in terms of employment law, only what their kind of mission statement is. That's what I meant. So apologies if I've offended anyone on that one, but I'm certainly not intending to comment on their policy themselves. So yes, anyone else, any other questions? No. Well, lovely. Well, thank you very much. quite a whistle stop tour. I've gone a little bit over the usual sort of half hour for the lunch club, but I think that was it. It was fun to kind of get in the manifestos. Um, Someone's asked, do I think Labour can do this in 100 days? I mean, in terms of changing all the changes they're making, that would obviously be a widespread, some quite big changes. So it would be, they'd need who knows? They've obviously, a lot of it was going to need consultation for a start. So they're not going to be big. There won't be. There may be some big changes quickly. They're not afraid of doing that in the past. If you think of 1998. Tony Blair came in and made some pretty quick changes, but I suspect that some of this certainly needs to be consulted on before it's going to just immediately be put into legislation. Though they have promised, this is this 900 days thing. They've promised to put legislation in quickly. Some of that I think will be legislation on we're going to consult now, that kind of thing. So how much notice, similar question, how much notice will we have to end 0 hours contracts? I mean, who knows? It's only, it's not necessarily ending 0 hours contracts. It's, as I say, it was, what's the word? Can't think what the word they use is, exploitative 0 hours contracts. So I would hope that no one here is using exploitative 0 hours contracts anyway, as opposed to ones that have a genuine, need and use, and is, mutually beneficial for an employer and an employee. Fantastic. A couple of people asked with the slides. I believe we usually send the slides out. Our team will sort that out for you. So I'll try and correct that 28 weeks, which I put in instead of days. But other than that, thank you very much, everyone. It's nice to have you all here. Thank you.